This question comes from Very Upset in Utica, and it is a bit of a lengthy question, so bear with us here.
Should I get a notepad?
Very Upset writes in and says, I purchased a home from the seller based upon a land contract. I moved my wife and my children into the home 4 months ago. Part of the agreement was that I would pay the seller's mortgage payments directly. Okay. Red flag. Land contract, mortgage payments. Okay. I have paid on their mortgage payments each month. The seller is now telling me that I have broken the agreement because the $2,500 deposit that I gave him 4 months ago is now NSF, non-sufficient funds. I honestly thought the $2,500 cleared the bank in our dealings. I rushed to the bank and purchased a certified check for the $2,500 and immediately overnighted it. He says he is not accepting it and that the purchase and the land contract are now both void, and he wants me out of the home before the end of the month. Can he do that? From Very Upset in Utica.
How about this? I'll make it easy on everybody, including the party who wrote this. First, I'd suggest that you contact the attorney who handled this transaction in the beginning. But no, seriously, wow. So in real estate law, everything has to be in writing, okay? Pretty much to be enforceable. Like any type of real estate agreements that you have to be reduced to writing. And that's pursuant to what we call the statute of frauds. And it's why they call it the statute of frauds, is to prevent people from making things up regarding one of the most important assets that most people in their lifetimes will ever own, which is real estate, okay? And there are exceptions to that statute. One of them is called partial performance. It's a legal theory. And whatever's happened in this whole transaction, at first blush, just listening to this, the first thing I'd say to this person is, okay, you're going to have a little fight on your hands, but you definitely need to go see an attorney. That's number one. You entered a contract and you did it, and it sounds like good faith, including giving them the good faith deposit that didn't clear. But you know, earnest money deposits have their own issue. They're not usually considered by some courts as material to a contract, meaning really important to a contract. It's really the main items that this person's performing under, such as making the payments on the mortgages for all these months. That is a material performance on the contract. Now, wow. Get ready. I'm going to say, Blair, I need to see the contract. But right. Okay, every time. But in this situation, I'd like to see the default provisions of that land contract. Now, if let's say this individual wrote that $2,500 check and it was obvious that it was going to bounce, or it was made, you know, they call it, it was uttered. They call it uttered and published, meaning that they made a bad check from the beginning. That's a problem, but it's not something that can't be rectified. This person went and cured what we call the default, which was the $2,500. That is certified, or
right, the second.
Yeah, we call it an official check now. They don't call them certified checks. They call them official checks.
Okay.
But he cured that default. So like, yes, it was a problem. It wasn't brought up for 4 or 5 months, according to this writer of this question. And then there was an issue. Meanwhile, he moved his whole family in, and they have moved their whole family in, and they've been making payments. So they performed. Are they late with the monthly payments? Have they done anything further with regards to, have they destroyed the home? Have they violated any of the other terms of the land contract? If they haven't, and the only issue is that $2,500 that the seller's trying to, push them out on, that seller got a benefit. And that benefit is that the buyer's been making their mortgage payments. So they can't go into court. I don't believe they can go into court and prevail at all, because these people did make up the 2,500 in a very short period of time based on what it sounds like.
Mm-hmm.
And what are the rules with regards to the default? Now, here's something just to ponder for your consideration. And that is, what if the default provision says, if I declare a default, any default, meaning that you didn't abide by the contract, you have 15 days to cure that default. What if this buyer did cure the default right away by going to get the certified check?
Mm-hmm.
You see, so it's a lot. It sounds really like there is a lot going on there, but really, it's not that bad, right? So there are times that people will call and I'll say, okay, it's gonna be okay. It's gonna be all right. And this is one of those times, like if they called in, I'd be like, don't worry, no, you'll be fine. You know, it's not something I could see a judge leaning towards the seller on at all. And I think that it's you know, not that $2,500 is a minor issue, but it's a curable issue. And I don't believe it's a material issue. And that's what land contract default provisions usually would talk about. They talk about two items. One's called a monetary default, which is, did you make the payment or not? That's a monetary default. That deals with your monthly payments. Are you current with your monthly payments? And the other defaults are called non-monetary defaults. The non-monetary default here is at $2,500.
Mm-hmm.
Got it? And he cured it. So I think you should relax. Now, I will tell you one thing with regards to subject to, that's a subject to mortgage, by the way, you know that.
Right. And that's what made me smile. You know,
Right.
I'm making.
I mean, they're legitimate. You can do them.
I know.
But you know, if if a mortgage company finds out, you might have an issue.
I know, like, do on sale. Maybe don't.
Right.
Maybe don't.
Yeah.
Yell about it to too many people.
Right. Most banks won't call the note, by the way, right now.
Sure.
But nonetheless, that's not really the main issue. The main issue, these people, I think he should see. Unfortunately, you know, if the seller continues to press, or if they try to evict under a forfeiture action, you're going to have an attorney on that. If you walk into court on your own, and I get calls where people will call us up after they went to court on their own and tried to tell the judge what was going on and losing their case, then they call us up. I can't help those people. I can only help people who, before they go to court for the first time, because, you know, unfortunately, that is a playground for lawyers, not for lay people.
Right.
It's a courtroom.
Yep.
So
that's
pretty much it. I mean, I hope that helped them.
Yeah. I think so.
That was a long question.
There was a lot going on there. Hopefully that was just a big wet blanket of peace all over this very fiery email or phone call that, you know, someone on your staff was dictated to. I'm not sure, but yeah, I can see it being very stressful. I have moved my family in, and now what, right? Especially in this type of market where you can't just, it's not easy to just make a lateral move. Oh, no problem, I'll just find another house. What other house? There are no other houses.
Right. And so what's the true motivation behind this from the seller, right? Does the seller want to sell it for more? Does the seller want to get, like, you know, I've seen sellers say, look, you know, you're in default, but if you give me an extra so-and-so, I won't go to court. You know, I've seen that. You know, that comes out in the wash later. So definitely consult with an attorney only if you get served with a forfeiture notice. If you don't, nobody can evict you. Nobody can do anything until there's a forfeiture, you know, order that's signed by a judge. But before you even get that, you need to go see an attorney. And that's
okay.
Right.
All right. Very good.
Excellent.
Very good for very upset.
Yeah.